Hi, everybody. Welcome to our Facebook Live. I'm joined by our special guest, Nathan Rutherford from Robbins Watson Solicitors at Burleigh Heads. And today's topic is all about the FIRB reforms and what we need to know from an estate planning perspective. Welcome, Nathan.
Thanks for having me, Tara. Very excited to be here.
And I have to apologize to everybody. The reason we're late, it's all my fault, nothing to do with Nathan. I'm just having a few tech issues these last few weeks, but we got here. So, yeah, don't let that impact on Nathan's presentation. Now, Nathan, I'm so grateful that you put your hand up and volunteered to present on this topic because I know next to nothing about FIRB. I always thought it was one of those things that only like the big deal maker, like, you know, merger and acquisition kind of joint venture resources clients had to deal with, and I've never really turned my mind to it. So when I saw the updates coming through that this was now something we had to consider in estate planning, my head was spinning. So thank you for agreeing to speak to us. Can you tell us a little bit about just what you do, your area of specialization, and how you came to start looking at the FIRB changes?
Yeah, absolutely. So I practice predominantly in estate planning and administration here. The full spectrum. We do some structuring work, complex wills and estates, that sort of thing. And from the administration side, it's the whole spectrum. Basically, so I started at Robbins Watson in August last year. I think in my first or second week, as things were starting to ramp up, I basically got an email from a partner saying, we've got a matter, they need FIRB approval, make it happen. So I spent a lot of time with the legislation trying to get my head around it because it's some pretty complicated legislation. There's a lot of sections that jump backwards and forwards, a lot of terms that are defined that don't really carry their usual meaning. So it is a little bit complicated, but it's just about trying to get used to the process. And then once you're, I guess, used to the law, then try to work out how FIRB actually start applying their policies to give approvals, that sort of thing.
Yeah, I feel like it's something that even just reading the legislation, unless you're getting your hands dirty and going through the process with a live scenario, it's like me trying to look at it, it was just had my head spinning. So what I might do is not waste any more time and let us get into it. Nathan has agreed to take questions, so please feel free to post your questions in the comments section. We will try to find some appropriate junctions to raise those, but just go ahead and put them in there. Also, if you want to share where you are, what the weather's like, if you're on holiday somewhere cool joining in, just let us know that people are watching. So that'll be it from me for a moment, and I will hand over to Nathan to start stepping us through his presentation.
Thanks very much for that, Tara. So as the reason you're probably all here, you've come across the very recent updates to the Foreign Acquisitions and Takeovers regulations, which remove the exemption to acquisitions by way of a will. So that was one of the major changes that came into effect on the 1st of January this year. There was actually a whole other suite, I guess, of amendments to the Act as well, but this is really the big one that's going to affect us as estate planning and administration practitioners, because we're now having to turn our mind to things that we've never really handled in practice before, and that has some pretty serious consequences for our clients if we're not talking about FIRB with them at the time. So I guess to start off with, I just wanted to give you a bit of an overview of the foreign investment regime. So we have our two governing acts. We've got the Foreign Acquisitions and Takeovers Act, which has the majority of the information, and then we have the regulations, which is where we go to for a couple of the little pieces of information that are quite important. When it comes to how the acts are actually administered it's broken up between the Treasury and the ATO. So any dealings with FIRB, if we're talking about residential property, then we need to be dealing with the ATO, and they have their own portal where you can provide all of your information, that sort of thing. And then if you're dealing with any other acquisitions, then we need to be dealing with the Treasury, and their system is quite complicated and there's a lot of hoops to jump through. I kind of thought for this presentation I'd focus mostly on residential land, because as you'll start to see, it's what we're going to have to deal with the most, because some of the thresholds, one of the things that a lot of people are worried about is that FIRB also applies to securities, other assets, that sort of thing. But the thresholds for those assets means that it's not going to be overly common, unless we have a situation like last year where in the midst of COVID-19, they FIRB updated their regulations and they actually removed all of the monetary thresholds. So as we go through, you'll see that these thresholds that were previously $60 million, $120 million, all became nil. And any dealings by foreign persons that fell within those kinds of action that are covered by the legislation, we were needing to make applications to FIRB for approval. And that's where a lot of the applications through Treasury happen. And there's a lot of information that you have to give them. So you need to satisfy the Treasury in those circumstances that the action proposing to be taken isn't, going to risk Australia's national security or anything along those lines. Which brings me to the next part. So the foreign investment regime is a national security regime. And when we're engaging with it, we always need to be cognizant of that, because that's going to guide a lot of the decision making here. And it's also going to affect the context of the regulations at the relevant time. So as we were talking about with COVID, having those nil thresholds was all a matter of national security at the time, but it had very significant effects for people who were doing very simple matters. So as I was saying before, the file that was dumped on my desk fairly early on at my time here was simply the purchase of commercial residential property, a hotel, basically. But because it was the purchase of a business, as well as the client was acquiring an interest in one of the units, a permanent right to live in one of the units while the business was owned, we had two different types of action, and the threshold for the acquisition for business had come down to zero. So we needed to engage with FIRB from that point of view as well. So to start with, I just wanted to cover what this change is that we've actually got to deal with now. So Regulation 29 of the Foreign Acquisitions and Takeovers Regulation, before 1 January said basically, so it talks about the excluded provisions. That's basically any provision of the Act that doesn't relate to the definition of foreign person, so pretty much anything. So FIRB approval is not required in relation to an acquisition of an interest in securities, assets, a trust, or Australian land, if that interest is acquired by will or devolution by operation of law. And then from 1 January 2021, we have that, we've got removed there the reference to by will, and now the only assets, the only acquisitions that relate to estates occur by devolution by operation of law. So I want to unpack those changes a little bit later, because there's some issues in the wording that have become rather problematic only now that the wording has been changed and that exemption has been removed. So I'll keep moving and then we'll come back to that because it's pretty important. So what does this mean for estate planning and administration practitioners? So put pretty simply, if we've got a beneficiary in an estate that is looking at acquiring an asset, and that beneficiary is a foreign person, we are likely to need FIRB approval, or at least need to turn our minds to whether it's required. So we can't just pretend this doesn't exist anymore. And when we're advising from an estate planning point of view, we need to be directing our clients to consider what this regime, what effect this regime is going to have on the beneficiaries of our estates. And if we're looking at doing any structuring work, exactly who our clients are and who these entities are and whether they are foreign persons, because the definition is incredibly broad, and that's what we're going to see in a moment. Now, one of the reasons this is so important and kind of very significant for our clients is because the fees to apply for FIRB approval are exorbitant. So what I've got here is a snip of the fee schedule for residential land. Now, since moving to the Gold Coast, I found that pretty much every second property here is worth between $1 and $2 million. We have clients who have very little cash assets, but the house they bought for $350,000 back in 1990 is now worth between $1 and $2 million. One of the examples that I like harping on about in this area, not so long ago, there was a property on Burleigh Hill that was purchased back in, I think, 1986 for $350K. It's just been sold for $4.5 million. So if we have a beneficiary who is receiving that property through a will, for example, they might need to apply for FIRB approval, and that application fee, as you'll see here, is $50,000. So for beneficiaries who aren't cash rich, that's a massive, massive outlay to try and receive property.
My jaw's on the floor. That's crazy.
Isn't it? Like,
yeah.
The idea that someone who is receiving property needs to pay $50,000 to receive it, or to have it considered that they receive it, because it's not always certain that they will get it. You don't just get FIRB approval because you apply for it. And I've actually got some of the policy positions that FIRB takes set out a little bit further in the slides, because they can be quite surprising. But so if we've got those, cash poor beneficiaries, we might have beneficiaries who are retired, who have no way of, trying to mortgage their interest because they're not going to be able to service a mortgage. It's just that it's fraught with all sorts of issues. And what it might mean is that we're going to start seeing a lot of properties being sold at an estate level because we can't pass those to beneficiaries.
And now I'm thinking about it, like, who bears the cost of that? Is it the beneficiary? Is it the estate? And then have we got issues around, are we reducing like the residue beneficiary's cash position? And
Absolutely. Yeah, I think that's a really good point, and it's something that I do kind of raise further down. I think it kind of has to be a beneficiary's cost. The onus is on the beneficiary to get FIRB approval. It's the acquirer who needs approval. Well, they don't need approval. They can acquire it. There's nothing to stop the property being transferred. But as you'll see, you need approval. The penalties for not getting approval are terrifying for these sorts of beneficiaries, and I think it's going to start popping up a lot. I have another matter at the moment where, and this one is part of a structuring arrangement where we've needed to apply for approval to acquire a mortgagee interest in a property. So we're doing a gift and loan back. The trustee, who we didn't act for back in 2006, they acquired the property and didn't get FIRB approval. So at the moment, we're trying to work out, well, what do the ATO need to work out whether they want to pursue this client or not, to recover the unpaid application amount, or whether they're going to penalise our client for not getting approval at the time. Now, trying to find records from 2006 is almost impossible. The solicitor that acted at the time has actually shut up shop and retired, and obviously they're not going to have records from back then. So that's a problem that we don't really know how to solve at this stage. So we'll just keep going.
Wow. All right. Well, you can don't let me distract you. Keep going with
your
presentation.
Right. It's a really interesting question. So what I wanted to start with, I guess, was who is a foreign person for the FIRB process. So our most common one that we're going to pop up with is an individual not ordinarily resident in Australia. Now, there are also another range of beneficiary or persons who could be considered foreign persons. So we've got corporations in there, we've got foreign governments, we've got certain regulations. But I think the main ones that we as estate planning practitioners need to focus on is individuals not ordinarily resident in Australia And the trustees of a trust, or the trustee of a trust, in which an individual who is not ordinarily resident in Australia holds a substantial interest, because as we know with our discretionary trusts, they're usually pretty broad and there's a lot of beneficiaries, and we're going to need to start considering who those beneficiaries are in almost all cases. Just in relation to companies really quickly, a quick summary is that a corporation is a foreign person if an individual not ordinarily resident holds a substantial interest. So when we're talking about corporations and unit trusts, a substantial interest is an interest of 20%, and an interest in those sorts of things is 20% of the voting power or 20% of the shares issued, that sort of thing. You should also be aware that FIRB have tracing rules. So where we've got various holding entities, they will trace the interest through to the ultimate holding entity. So I've had to do that before. We need to, send off 4 or 5 different company searches and then satisfy FIRB as to all of the directors in the meantime and all of the shareholders, that sort of thing. It's also worth noting that, so as we've got these definitions here to talk about 2 or more persons who hold an interest, there are provisions about aggregating the interest held by what the Act talks about as associates. So people who are relatives, people acting in concert, business partners, other entities of which the foreign person is a senior officer. So the foreign person is very, very broad, and we always need to be turning our minds to exactly what the circumstances are and whether they fall within this definition, basically. So because our main focus is individuals not ordinarily resident in Australia, or the trustee of a trust in which an individual is not ordinarily resident in Australia, it's worth looking at who is ordinarily resident in Australia. So we've got a few elements here. So this is section 5 of the Act. So our first element is they're not an Australian citizen. So that does mean, are they a naturalised Australian citizen, or are they just the holder of a permanent resident visa or some other sort of visa, which becomes relevant when we start looking at the other elements. So a person who is not an Australian citizen is not ordinarily resident if they have been in Australia, or if they've not been in Australia for 200 or more days in the last 12 months. And at the time, if they were in Australia at the time, their presence was not subject to a limitation as to time imposed by law. So I think I kind of read that the wrong way around, so I'm just going to run through that again. So if we have a person who is in Australia and who is not an Australian citizen, they will be ordinarily resident if they have been here for 200 or more days in the last 12 months. And while they were here, their continued presence was not subject to any limitation as to time. So if we've got a beneficiary who was, or we've got a person we're talking about who has been here, but they're on a temporary visa, or their visa is going to expire at some stage in the future, that is a limitation as to time. So this is where our permanent residents, while not Australian citizens, they might not have limitations as to time imposed on their visa. So that's where things change a little bit. So we need to be considering who are these people and how are they here? What are the rules about their continuing to remain in Australia? And then if they're not in Australia, then immediately before their departure, their presence here was not subject to any limitation to time. So that's pretty straightforward for that second part there. And then we have trusts, or trustees, I guess, as foreign persons. So what we need to do is we need to consider who all the beneficiaries of the trust are. So break out that schedule, write down every person who might be any sort of beneficiary from that trust, and then see if we can trace through whether they are in fact an Australian citizen, whether they are here on through some mechanism in the Migration Act, that sort of thing. So break out who those beneficiaries are, and then we start considering what interests they have in the trust. So straight away, our first thought, a discretionary beneficiary has no interest in the trust. Their only interest is the right to the due administration of the trust. I've got the note there, section 18.3. So that's our classic deeming provision. If a trustee has the power or discretion to distribute income or capital to a beneficiary, that beneficiary is taken to hold a beneficial interest in the maximum percentage of the income or property of the trust. So all of our discretionary trusts, similarly to our aged care laws, if we have a beneficiary with an interest, they hold the maximum interest in the trust. So when we go back to our generic trust deeds, who are our beneficiaries? So we think principal beneficiary, parents, brothers, sisters, children, grandchildren, spouse of any of those people, any related entities. You can kind of just see this branching into some big, massive family tree. And we're going to need to work out if any of those people are foreign persons or not, to work out whether our trust is a foreign person. So this is a pretty big task, and we need to get it right.
I mean, Nathan, I'm just thinking, like, what about a tertiary, like if often the trust will include like a tertiary beneficiary class, which includes other trusts of which a primary beneficiary of the original trust is also a beneficiary. Like it just keeps going and going and going.
Yeah, this never ends. It goes so far depending on how broadly our trustees are drafted. It keeps going. It's pretty scary, actually. That's really all I've got to say about how far we need to take this idea of a foreign person who is a beneficiary of a trust. So the next thing I kind of wanted to go through was what sort of acquisitions the Act applies to. So what dealings with assets should trigger our thoughts about whether the regime applies. So the regime applies to securities. So we're talking about shares in a corporation or units in a unit trust. It applies to what the Act calls assets. Now, obviously, assets is a ridiculous term because it means basically anything. But in the context of the Act, we're talking about acquiring an interest in assets generally of a business. So if we think about acquiring a partnership interest, that sort of thing, that's when the regime starts to apply. So we don't need to be worried about foreign persons acquiring an interest in a car or something along those lines. It's really the regime applies to assets of a business. It applies to acquiring interest in a trust. So that's set out in section 11. So a person holds or acquires an interest in a trust if they hold or acquire a beneficial interest in the income or property of the trust, or they hold or acquire a unit in the unit trust. So that's pretty straightforward. And then it also applies to Australian land, and the Act breaks down what it means by Australian land because it treats all of them differently. So residential land, all residential land is kind of treated the same from an application point of view, but it's not from a policy point of view. So we've got three types of residential land, being vacant, new or near new, or existing and established residential land. We have agricultural land, which is just land that's used or could reasonably be used for a primary production business. And then we have commercial land, which is any land other than land used wholly and exclusively for primary production, or any land other than one on which there is at least one dwelling, or on which the number of dwellings which could be built might be less than 10, is less than 10, sorry. So the Act then breaks down multiple types of actions that you can take in relation to all of those assets. Now, this is where things get really complicated, and I can't go through it all in great detail. So just by way of example, we're half an hour into this live and I'm on slide 10. So I'm going to skip through some of these things, particularly in relation to significant actions, because I mostly just want you to know that they exist. Because while we have these thresholds, you're not going to need to be dealing with them unless we're talking about substantial asset values. So a significant action is generally an action to acquire interest in securities, assets, or Australian lands. And generally the action will only be a significant action if the action meets the threshold test. There is some overlap between significant and notifiable action. So often we have a notifiable action will generally always be a significant action, but there is no requirement to notify the treasurer if you plan on taking a significant action. You should be aware, though, that the treasurer can review the transaction if they become of the opinion that there's national security concerns, and they have the power to, force the beneficiary, force the acquirer to take actions such as sell the property to divest themselves of the assets. Notifiable actions, though, are things that we need to notify the treasurer before we take those actions. So this is where we're going to need to be thinking about residential land that's being acquired through a will by a foreign person. Now, just to explain why this is so important, Section 84 of the Act sets out the consequences of a foreign person failing to give notice to the treasurer. The maximum penalty is 10 years imprisonment or 15,000 penalty units for a natural person. Commonwealth penalty unit is currently $222, so that is a maximum penalty of $3.3 million. Or if we're talking about a corporation, the maximum penalty units are 150,000 penalty units, so $30 million. So this has significant consequences for our clients if we're not doing it. So notifiable action is generally an action to acquire a direct interest in an Australian entity or an Australian business that is an agribusiness, to acquire a substantial interest in an Australian entity. And as we were talking about before, that substantial interest is an interest of about 20%. Or any action to acquire an interest in Australian land. There are also a couple of different types of actions. Those are notifiable national security actions or reviewable national security actions. I'm not going to go through them because we don't have time and they're not overly relevant to what we're doing. So I'm setting out the significant actions here, but I'm just going to go through what kinds of actions might need to be taken. I don't want to touch on what all of the conditions are because we just don't have time. So the types of actions that you need to be thinking of: acquisitions of a direct interest in an agribusiness. Now, a direct interest is about 10%, or the ability to control the policy or the decision-making for the business. The acquisition of interest in securities in an entity, that's a really confusing phrase. It basically just means shares. The issue of securities in an entity to a foreign person is, or to a person who already holds shares in the entity, for example, is a relevant action. Entering into an agreement about how decisions will be made by a foreign person in relation to an entity is an action that's relevant, or changing our constituent document might also be relevant. If we start looking at significant actions relating to businesses, we're talking about actions to acquire a direct interest in an Australian business that's an agribusiness, to acquire interest in assets of an Australian business, or to terminate a significant agreement. So have a look at those definitions if you're wanting to delve into this further, but otherwise I'll just keep moving on. So this action here, the action is for a foreign person to acquire an interest in Australian land. That is one that is also going to be, or very likely to be, a notifiable action. So this is just an example of where they overlap. And some other actions that are prescribed are investments in Australian media businesses or actions by foreign government investors. With the significant actions, one of the elements is that there is a change in control. So I'll touch on this briefly, but basically a change in control happens where one or more foreign persons would begin to control the entity, or if one or more foreign persons already controlled the entity, then another foreign person would step in. A person controls an entity if the person can determine the policy of the entity or the business in relation to any matter, or if they're acquiring an interest in securities, then they hold 20%. So we just need to be mindful where we have significant changes in control of our entities there. Now, Section 47 sets out what our notifiable actions are. Now, this one is what I want to delve into in a little bit of detail because it's what we're going to be dealing with the most. So all of the actions that are set out in the legislation generally have multiple conditions that need to be met for it to be caught by the FIRB regime. So for our Section 47 actions, the first condition is it needs to be a certain kind of action. So an action to acquire a direct interest in an Australian entity that is an agribusiness, or an Australian business that is an agribusiness, or an action to acquire a substantial interest in an Australian entity, or the one we're going to be dealing with the most, to acquire an interest in Australian land. So straight away, we're talking about acquiring an interest in Australian land. If that's happening, we need to turn our mind to who is acquiring that interest. Now, just by way of reference, I've got the reference there to what is a direct interest. So we've got 10%, 5% if there is a legal arrangement relating to the business, so management rights, that sort of thing, or any percentage interest if it allows the acquirer to influence the policy, that sort of thing. So what is an interest in Australian land? So this is set out in Section 12 of the Act. The main ones that we're going to come across are a legal or equitable interest, other than an interest under a lease or license, a unit in a unit trust, a profit apondre, or an agreement to share the profits from the use of an Australian land. So basically, anything apart from those things is an interest in Australian land. It's also an interest in a lease or license, which gives rights to occupy for a term more than 5 years or likely to exceed 5 years, and that includes any extensions or renewals. Or an interest in what is basically a land-rich corporation, trust, or agricultural land trust for Australia, or agricultural land corporation, or a share in a corporate trustee of any of those entities. Now, the second condition for a notifiable action is whether the threshold test is met. Now, Section 51 kind of sets out what the threshold test is in relation to a whole array of actions that can be taken. I just want you to know that Section 51 is there because it's not directly relevant to what we're dealing with now. So Section 52 talks more about the threshold test for land. So Section 51 relates more so to our interest in entities or acquiring securities, that sort of thing, whereas 52 relates to land. So there are a wide range of land or types of land that do not have a threshold value. So our threshold is still nil, and that's residential land. So residential land of any value is going to trigger us needing to consider FIRB approval if it's being taken by a foreign person. So residential land, vacant commercial lands, a mining or production tenement, land acquired by a foreign government investor, that sort of thing. So that's not directly relevant. Now, the threshold test for agricultural land is value of the interest held by the foreign person already, plus the consideration for acquiring the new interest. And then there is a prescribed amount in the regulations. So we'll move on to what these prescribed amounts are. But our monetary threshold in relation to agribusinesses are $60 million. In relation to other types of entities and businesses, between $275 and $1.1 billion. So that's what I wanted to, that takes me back to where we were before, where we're not going to need to be considering a lot of these acquisitions because our monetary thresholds are so substantial. But as we said, last year, all of these became nil. So acquiring an interest in a business, while we would only need to deal with that if that was previously between, sorry, I just tucked back a slide. If that interest is between 275 million and 1.9 billion, if our acquisition is above that value, that's when we need to engage in the process. But last year, that was $0. So there were a lot of actions being taken that needed further approval last year, and that caused huge backlog in their application process.
Nathan, are the thresholds still 0 or have they been returned?
No, sorry, I should have clarified that. This is the thresholds as they currently are. So as of the 1st of January, our thresholds came back. So do check your thresholds for a lot of things. But the main thing is that our land, our residential land, currently has no threshold value. Sorry.
Yeah.
So we're always needing to deal with this if we're talking about residential land. Now oh, sorry, did you have a question, Tara?
Oh, I just said, that's really interesting that there's no threshold for the residential land.
Yeah, so that's when, that's why, like, from our estate administration, I guess, point of view, or estate planning point of view, we're always going to need to be considering this if we're talking about, you know, a shack somewhere that's worth about $75,000. We're still going to have to potentially go down this process with our clients. The effects of this are pretty big. So I guess then the next condition for working out if an action is notifiable. Now, I do want to point out this probably all sounds like gibberish. I've got an example in a minute to work through that will make this all a little bit more manageable. So our kinds of entities being covered. So if the action is to acquire a direct interest in an Australian entity that's an agribusiness or a substantial interest in an Australian entity, the third condition is the entity being acquired as an Australian corporation that carries on an Australian business, or they're a unit trust in Australia, or they're an Australian entity that is the holding entity of one of those things. But where we're talking about residential land, and we're not talking about an agribusiness or a substantial interest in a corporation or a unit trust, our last condition is that the action is to be taken by a foreign person. So where our three conditions then are, it's an action to acquire an interest in residential land, that the threshold test is met, and it always will be for residential land, and that the action is to be taken by a foreign person. So where we have those three things, we need to notify the treasurer. And what I've got next is a little bit of a work example about an estate matter where we can look at a couple of different types of these transactions. So the example I've got here, Dad passes away on today, 15th of April, 2021, and is survived by a de facto spouse who I've called partner in Australia. So Dad was born in the US, but moved to Australia sometime after separating from his first wife. We've got new de facto partner. Dad's now an Australian citizen. Dad is survived by his partner, obviously, and daughter from his first marriage. Daughter is a US citizen who has been in Australia for the last 12 months on a temporary visa to care for Dad. Dad's assets are a half interest in a primary production partnership, which owns cattle, plant, and equipment. There's no land, so we'll ignore the land side of things for now. Dad's interest in the partnership is worth $3 million. We then have his other assets being a half interest as tenant in common in the principal place of residence. The other half is owned by the partner. Property is worth $2.5 million. And then we've got some cash. Dad's will leaves his estate as follows. So we've got the primary production partnership interest being left to daughter. And then we have rest and residue to the Testamentary trust, which provides that partner is trustee and appointor, and our capital and income beneficiaries are our general people, partner, child, stepchild, or adopted child of any of those people, related entities. So I've broken down those two different acquisitions there. So we've got two separate acquisitions that we need to deal with, because we've got an acquisition by daughter and we have an acquisition by the trustee of the Testamentary trust. So for acquisition one, we're talking about an action to acquire a direct interest in an Australian business that is an agribusiness, basically because we're acquiring a percentage of that partnership. So the next condition is our threshold test. As things are at the moment, our threshold test says that the action, that our threshold is $60 million. Our value here for the partnership interest is $3 million. So at the moment, our threshold test isn't met, but last year, this was the kind of acquisition that would trigger for engagement if the same rules applied, if there was no longer that exemption of acquisitions by way of a will. Our third condition is that the action is to be taken by a foreign person. Now, daughter is a beneficiary. Now, I'll go through this in more detail, but daughter is beneficiary daughter is a person who is a US citizen who has been in Australia for the last 12 months continuously on a temporary visa to care for dad. So when we go back to that definition of an individual who is not ordinarily resident in Australia, that gives us a foreign person. So not an Australian citizen. She has been here for more than 200 days in the last 12 months, but her presence here is subject to the limitation in her visa. So she's a foreign beneficiary, and that means that all of our conditions for this acquisition are met, and we need to be notifying the treasurer, this isn't a notifiable action, this is a significant action. So we don't need to notify the treasurer, but she needs to be aware that the treasurer could review this transaction further down the track. So we don't need approval, but it's absolutely something we should be considering getting if our client is worried that FIRB's going to pop up in 2 years' time and want all of the details of this transaction, because then the daughter's going to come back on us and say, you didn't give me all of this information. I've now got the Foreign Investment Review Board chasing me down, trying to get all of this documentation. I didn't know that that was the process that I needed to follow. We can tell her she didn't need to follow it, but she's the one that's going to be stressed out and is going to be looking for someone to blame. So if we move on to acquisition 2 now, which is kind of the more common one that we're going to be dealing with a lot. So we've got our principal place of residence passing to partner as the trustee of a testamentary trust. So this kind of looks like our notifiable action because it's in relation to residential land. So this action meets the first condition because it is one to acquire an interest in Australian lands, and it meets the second condition because the residential land is land without threshold value. So there's no threshold test to meet. Now, the third condition doesn't apply because we're not talking about an agribusiness or an Australian entity. So we've got the last condition there being the action is taken by a foreign person. So this is when we need to, again, pull out our schedule to our trustee and work out who our beneficiaries are. Daughter, in this case, is a stepchild of new partner, most likely, or the trustee might, or the will might say that a child of the deceased, for example, is included. So where we have that, we have the beneficiary, who, as we've just talked about, is a foreign person. Now that means our trustee is a foreign person because we've got that deeming provision that says if daughter has an interest in the property or an interest in the income or capital of the trust, she has an interest in the maximum amount that could be distributed to her, which for a standard discretionary trust, that's the whole lot. So we have a foreign person trustee. So we then have our trustee making an acquisition that we need to notify FIRB about. So it is really important that we are considering these things, because if we just stopped and we said, all right, property is being distributed to surviving spouse to hold on trust, essentially for herself. In most cases, our testamentary trusts are basically just alter egos of the principal beneficiary. If that's what's happening and we do that, we've potentially exposed our clients to thousands of dollars worth of fines and potentially 10 years imprisonment. So it is really important to stop and think about exactly who the beneficiaries of our trusts are when we're distributing when we're distributing residential land through our wills. So I really can't stress that enough. Now, one of the other things that hasn't come into effect yet, that is going to become relevant, not just for our testamentary trust, but essentially for all trusts. In the next couple of years, now this is in the legislation now, it just hasn't been set up, we're going to have a register of foreign ownership of Australian assets. So once this register is set up, a person must notify the registrar if the person becomes a foreign person and holds an interest other than an equitable interest in Australian land. So all of our trustees, obviously they hold the legal title, that's how the trust works. All of our trustees hold an interest other than an equitable interest in Australian land. If we have a beneficiary, or we've got our classes of beneficiaries in the trust deed, and someone falls into that class that is a foreign person. So child goes and marries someone overseas, or child goes overseas. I've got two friends who separately have been to Canada and come back with spouses. So in that example, if we've got one of these trusts that refers to our children's spouses, we've now got the trustee becoming a foreign person. And we are going to have these rules that say the trustee must notify the registrar within 30 days of that person becoming a foreign person. So that itself is a pretty big onus and puts a lot of responsibility on the trustee, because failing to notify the registrar, it's a civil offence, and it carries with it 250 penalty units. So that's about $50,000 as your maximum fine for failing to notify the registrar that you've become a foreign person, and you may not be aware of that if you're a trustee. So that's
wow,
the law.
Nathan, I can just see how far-reaching this is, and how many basic admin matters that this could potentially come up on if there is a foreign person. Now, I just think anytime there's someone foreign on your file, you just have to have all the alarm bells ringing to raise all these issues now.
Yep. I had that on Monday. I have an Australian citizen who he didn't have children, so he's just got his surviving spouse. He just had his spouse who passed away a couple of years ago. So the only other beneficiaries of his will are his sister and nephew, who are somewhere in Eastern Europe. I can't remember the country, but they're overseas. And he's got a property in Palm Beach. If they want to, move over here to acquire that, property in Palm Beach easily going to be worth between 1 and 2 million. So straight away, we're looking at that $12,000 application fee to apply for it.
Can I check, Nathan, is that application fee for all of the acquisition types? You said that there was the significant action that may or may not need notifying. So is that...
No, so the one that I've extracted, now I'm not sure of the others off the top of my head, but the ones that I've extracted are just in relation to residential land. So there may be others that are less. I actually think the others are much more generous. It's really, there's a lot of burden on residential land. And as we'll see with some of our policies, there's not going to be any point with applying for FIRB approval in a lot of cases. And that's what I'm going to get to right now, actually. But I have just seen a couple of the questions that are there that I think are really important. So someone there has said this doesn't apply to wills written January 2021. Does it? They've asked the question. My response to that is, I think it does. There's nothing that says that it doesn't. This law applies to acquisitions. The acquisition itself happens when the deceased estate is administered. So we're not talking about like the New South Wales stamp duty regulations where it says, where we're talking about foreign persons as beneficiaries of a testamentary trust. And we had that, that grace period where up until, I think it was 30 December, was it? Where we could amend those trust deeds. We don't have anything like this. The only thing that has come out of this legislation as it applies to us is those words, by will. So I think it does, and that's horrifying. A whole lot of structuring that clients have done is now going to be undone by this. So what I want to do, because I am conscious of time, is I want to run through the policy positions that FIRB actually take. So because this is going to guide whether there's any points in applying for FIRB approval. So FIRB actually have some pretty detailed guidance notes there, and I suggest having a look at them if you want more information about this process. And I've actually got links in the end of the slides. And Tara, I have amended the slides a little bit, so I will send those through to you when I'm done. But I've extracted some of the main parts here. So if we have vacant land, generally approval will be granted on conditions. So the first condition being the purchase price is not more than the amount being approved for. The acquisition of the land being registered within 30 days of settlement. At least one residential dwelling being built on the land. So if we're talking about vacant land, we need to build residential property on the land if it's for that purpose. Construction of the dwelling being completed within 4 years. Evidence being given to the government within 30 days of the construction being completed. And the foreign person not selling, transferring, or otherwise disposing of their interest in the land before construction is completed. So that's that last one. That's a pretty big one. If our client's circumstances change, they can't just go and sell the land off to someone else because one of them's lost their job and they can't get that mortgage anymore, or they can't meet the repayments. So that's a pretty serious thing. But these are the conditions that FIRB is going to apply to approvals to acquire vacant residential land. Now, I want to talk about what are new and near new dwellings. So a new residential dwelling is one that is or has been built on residential land, has not previously been sold, and has not previously been occupied. So all of our new developments, that sort of thing, with wherever basically a first home buyer is going to be entitled to that benefit is what we're talking about here. A near new dwelling is one that will be or is being built on residential land, is part of a residential development, and was previously sold by the developer of that development, but transaction didn't settle, and has not previously been occupied for more than 12 months in total. Now, if we're acquiring that sort of property, our conditions are essentially that the same sort of thing, purchase price is no greater than the value specified in the approval, and that the acquisition is registered. Now, there's generally no ongoing conditions on their use, on a foreign person's use of that property. So there's a limit on the number of residential properties, though, that a foreign person can own. So they can't own 5 or 6 new properties. Now, that's those two. The one that's really scary is established dwellings. So this is an extract. This is a screenshot of FIRB's policy on established dwellings. Now, that's anything that's not vacant land or near new. So pretty much any property that passes through a will. A non-resident foreign person is generally prohibited from purchasing established dwellings. So I want to break that down. So a non-resident foreign person is generally prohibited from purchasing established dwellings. So if we have, yes, the guidance note uses the word purchased, but I think it's also going to cover acquisitions by will. So my question here, and I think the end result is that if we have a property passing through a will that is an established dwelling and we have a foreign person beneficiary, that property can't be acquired. It needs to be sold. And I think that's a really terrible outcome for a lot of people that are going to lose, their family homes because they are a foreign person or because it's going into a trust that has a foreign person beneficiary. And unfortunately, there's no way around that. You might try and apply to FIRB for approval to purchase it. But if the position is that there's generally a prohibition on acquiring it, I don't think you're going to get very far. Now, there are these exceptions for temporary residents. Now, a temporary resident is a person who is essentially on a bridging visa while they apply for permanent residence or citizenship. They can acquire an established dwelling if they are going to redevelop the land, but the redevelopment needs to actually increase Australia's housing stock. You can't just knock down and rebuild. We're talking about kind of subdivision, that sort of thing. Or if it's a foreign controlled company and they're acquiring property to house Australian-based staff. So those are our guidance notes. But what do we actually do in estate planning? So we're going to need to work out what our clients' intentions are in relation to their residential land. So remembering that foreign persons are generally prohibited from acquiring established dwellings. So we're going to need to have very frank discussions that sometimes these properties can't be kept, and we're going to need to lose that emotional attachment to land. And then, are there sufficient assets for appropriation? So can we appropriate the property to another beneficiary who is not a foreign person? And in the case where we've got a standard mum and dad will leave everything to the 3 kids equally. Part of that's the residential property, and one of the kids has acquired citizenship somewhere else and given up their Australian citizenship. Can we appropriate the property towards the local beneficiaries if we want to keep it, and then appropriate cash towards the foreign beneficiary? Is that an option based on the estate? Can we set up the estate in some way so that there are more assets there to appropriate if we need to? So I think that's something that's very important from an estate planning point of view. And then I think we also need to consider what potential is there for a beneficiary of land to become a foreign beneficiary. So a lot of our clients are going to say, this is never going to apply for us. And then we'll go and set up that normal testamentary trust. But the example I gave before, 2 friends who went on working holidays in Canada and came back with Canadian partners and are now living in Australia. If they're a beneficiary of a testamentary trust and the testamentary trust includes spouses, that trustee is now a foreign person. It's so easy to be caught by this. So I think it's really important that we are reality testing our clients, not just saying, listening to the client say, oh no, it's never going to happen. We need to test the likelihood and make them realise that this is a very serious possibility and it can happen very easily. Also, from an estate planning point of view, we need to consider who the beneficiaries of all of our entities are. So I think one of the things that's, I guess, really important is if we're talking about rearranging our structures, moving shares from a land-rich entity into a friendly discretionary trust, that sort of thing, or into another related entity, we need to make sure that our beneficiaries of the related entity aren't going to be a foreign person, and that's going to make our, I guess, holding entity a foreign person. That's something else we need to keep in mind. And then I guess what I call the cheap and nasty option, because I don't like it. I think the only foolproof way to try and avoid this being an issue is we need to start excluding foreign persons as beneficiaries of TTs. If our clients do not want to turn their mind to this, we should probably really seek their instructions to exclude those people. And that's going to have some pretty serious consequences if we have a beneficiary who becomes a foreign person. There's no prohibition, as far as I can see, on amending the deed after an asset has been acquired to then include foreign persons. But I'd be really worried about amending. So for example, if we've got a child who is a foreign person, and a child who is a foreign person from a testamentary trust point of view, and the trust acquires residential land, and then we amend the deeds to remove that prohibition on foreign persons acquiring, I don't think that itself is an acquisition that needs FIRB approval. But I'd be very concerned that we might have just caused a resettlement of the trust, and we might be looking at all sorts of stamp duty and CGT issues, because our takers in default, if we're talking about secondary beneficiaries or issue of the primary beneficiaries, our takers in default have just changed. So I think that's worth considering as well. And that's why I don't particularly like the option of excluding foreign beneficiaries, but it's really the only way I can see around this. Now, from a estate administration point of view, I actually want to break down what this change is. So our change is just taking out the words by will. So pre-January, it was acquired by will or devolution by operation of law. Now it's acquired by devolution by operation of law. So pre-January, we've got acquisitions by will, pretty straightforward. We've got a testamentary document through which our beneficiary acquires an interest. We've got devolution by operation of law, which is generally how our LPRs acquire legal ownership of estate assets. We're not, so that's what devolution by operation of law means. We talk about it in the context of LPRs acquiring those assets or trust property vesting in the public trustee, for example, if we've got a trustee who passes away and there's no default appointment in the deed. But what about intestate estates? I don't think an intestacy forms part of the phrase devolution by operation of law, because a person acquires an interest on intestacy through a distribution. There's no absence of voluntariness there that is usually characteristic of something devolving on someone else. But I don't think it would be just I don't think it would be just if intestacies were excluded from the exemption as it previously was. But now that we move to the new position, we've got the question of, again, I think it's much more clear that intestacies are not included at all, and that the only acquisition from an estate point of view that is exempt is the acquisition by the LPR as trustee of the estate. So we've got the exemption for the LPR, but whether we're talking about a will or an intestacy, we're needing to deal with this process. And one of the reasons that becomes important, I guess, sorry, I've just got a snip there of the extract relating to devolution by operation of law that's in the Key Concepts Guide published by FIRB. So have a read of that in your own time. Joint tenancies. So at the moment, and this is something that a lot of our conveyancers will know, if you have a person who is the spouse, or a foreign person who is the spouse or de facto partner of an Australian citizen, a person who holds a permanent visa or holds a special category visa, they do not need FIRB approval to acquire an interest in property, in residential land, if they are acquiring that interest as joint tenants. So one of the first things we usually do if we're talking about testamentary trusts for the surviving partner, is we generally immediately go to severing those joint tenancies. So that way, if we're really worried about asset protection, the deceased person's interests will fall into the testamentary trust. We need to pump the brakes on those sorts of things, because that's going to trigger FIRB involvement from an estate point of view. So if we've got, so from a joint tenancy point of view, we've got both parties acquiring the whole of their interests together. The minute we sever that joint tenancy, we separate that interest, and both parties now hold 50%, if that's the way we want to do it. We now hold half an interest each. And through the will, we now have an acquisition instead of that principal place of residence passing on survivorship and being considered, I guess, a devolution by operation of law. So always keep your joint tenancies in mind and don't go jumping headfirst into it thinking it's the best thing to do in all cases. From an estate admin perspective, we should probably talk to the beneficiary about whether they want to take property in specie. I know that technically if we're acting for the executor, it's not something we need to do. We can make that decision, but it's always better to keep the beneficiaries on side and not just tell them how it's going to work. We should probably talk to the beneficiary about how FIRB approval is going to be paid. My opinion is that it's probably not an estate expense. So as we talk about our special expenses relating to acquisitions of specific gifts in a will or specific assets in a will, if we have a beneficiary who is acquiring a property, for example, and that property needs to be maintained or improved during the administration process, generally those costs are borne by the beneficiary. The cost of sending money overseas generally is attributable to the beneficiary. If we have a beneficiary who is wanting to acquire an asset in specie, I think applying for FIRB approval is the responsibility of the beneficiary and not the estate. Now, I'm happy to debate that one if anyone has a different view. And the reason I've kind of formed that view is there's no positive obligations on the LPR. The acquisition is by the beneficiary. So I think it's just a matter of making sure our clients and ourselves are off risk by making sure the beneficiary knows what their obligations are. And then if our client, for example, is going to become the trustee of a testamentary trust, we should probably make them aware that FIRB compliance is an ongoing issue. So if they are going to acquire further assets in the future, they should always consider whether they've become a foreign person trustee. Now, I'll touch very quickly on the application process because I know we're out of time. I've got this slide and one other. So we need to provide FIRB with all of our information when we're applying. So all of our intermediate companies that are along the way, we need to provide them with ultimate holding company details, copies of passports, copies of visas. We need to prove the foreign person's identities to FIRB along the way. And then, as we're talking about with residential land, the application is to the ATO. Now, the ATO portal is not overly nuanced. It kind of covers 3 different scenarios. Having dealt with the ATO before, they will just tell you, pick a scenario that kind of applies, tell them what is actually happening in a cover letter. So cover letters are your friend. Just fill in the application form as best as possible, but include all of your information in the cover letter. And then finally, I've just got some relevant links there, so that way you can look at these key concepts, guidance notes, the residential land guidance note, the guidance note about fees, and there is a detailed application checklist if we're making an application for something other than residential land that talks about all of the requirements you have to give the Treasury and goes through things like the national security test. So I guess that's where I want to end my slide because I know we are running out of time. So Tara.
Thank you, Nathan. That is so comprehensive, and I can see how deep you have had to dive into this. And even then, there's just so many nuances and questions coming up. Do you have a few minutes for us to answer some of or discuss some of the questions that have been posed?
Yeah, absolutely.
Okay, I loved Lucy's question, and thank you for being so patient, Lucy, about whose job is it to advise the client if a beneficiary is a foreign person or not? Is that us as lawyers? Is it the accountants?
Look, I don't, it depends on what role we're taking, I guess. So if we're acting for the executor, I don't think there's any, obligation on us to make sure that the beneficiary has gone through this process. But I think from protecting the executor, just, I'm not sure where the legal responsibility would lie, but we want to make sure our beneficiaries know that this is something that they need to do. So that way our executor is protected further down the track. The beneficiary comes back and says, you're meant to act in my best interests. Why didn't you tell me that this was an issue? At least we can get ourselves as lawyers off risk and the beneficiaries off risk, the executors off risk by pointing that out to the beneficiaries. I don't think it's too much of an issue from an accounting point of view, as in I don't think there's too much of a responsibility on an accountant to let our beneficiaries know or let the client know that this is going to be an issue because they're not really dealing with that process. This is the acquisition by the beneficiary is going to happen when the property interest is transmitted, or transferred to them, whichever way we're going. So I think it very much is a legal issue that obviously our accountants can point out to our clients. That's always fantastic when you've got a beneficiary being told 2 things by 2 separate professionals. They'll generally start to listen. Yeah.
And I think maybe Lucy's comment is informed by the accountants are typically doing this from the definition of Australian tax resident.
Yes.
Anyway, which is they're probably more used to doing that, whereas we would refer that on. But this is a different definition, I think, to the that definition.
Yeah, so it's obviously very similar. It's 200 days or 183 days. Pretty not sure what the distinction is there in those 17 days. that's relevant for FIRB purposes. But it really comes down to what their migration status is as well, and what their visa actually says.
Have you had, by chance, and it's totally fine if you haven't, have you looked at the definition of foreign person under some of the stamp duty and land tax foreign purchaser surcharge acts, and like how they, because I think some of those acts, like the New South Wales one, actually refers to this definition but amends it slightly. Have you looked at it?
No, I haven't. I'm sorry. I'm actually embarrassingly behind on the New South Wales land stamp duty issues. I've just been hoping that I haven't had to deal with that just yet, but I'm sure I will have to at some point.
Well, I can see that you've been bogged down in the FIRB issues.
It's legislation is basically like a Frankenstein's monster. I think it started in 1975 and has just been amended to death by the government of the day.
Yeah, I'm just kind of looking at it going, whoa, because I've just updated like my precedents, and for the people who are using my precedents with the foreign person land tax surcharge duty, and now I'm like, well, we need updates for this one as well. And so how many definitions of foreign person can we have? So the next question I had one for you from me is the scenario where you've got Australian resident, Australian citizen clients, and they've got like an adult child working overseas for a few years, right? They maintain their citizenship. Are they a foreign person? I read an article by someone from EY Law, and it was really vague about whether they were or not a foreign person.
I don't think so. So if we go back to that definition, those two definitions. So a foreign person is an individual not ordinarily resident in Australia. So that's the example we're talking about here, an individual not ordinarily resident in Australia. And then our next slide talks about an individual not ordinarily resident in Australia. So an individual who is not an Australian citizen is ordinarily resident. So I can see the ambiguity, but
can I see that first slide again?
Absolutely. Absolutely. No, sorry, I have lost it.
Oh, that's all right. Yeah, well, this is just a one-liner, and it says, importantly, an Australian citizen who is living overseas may be a foreign person under the FIRB regime. There is no specific rule for determining whether or not an Australian citizen is ordinarily resident in Australia. So they're just saying it's not addressed, I guess, which is what you're saying too.
Yeah, I can see the gap there, that a foreign person is an individual not ordinarily resident in Australia. So if we have an Australian citizen who is overseas, they're an individual who's not ordinarily resident in Australia. But then when we have a look at that definition of an individual not ordinarily resident in Australia, it talks about a person who is not an Australian citizen.
Yeah.
So, yeah, I don't know. Now, what I should...
is it section 4 like end, or does section 5 clarify section 4?
Well, what I might do is let's open up, and I'll see if I can share that slide nice and easily. I might just open up the actual legislation. We can have a look. Sorry, I've just got to kill my screen.
And I mean, we can take this offline if you want, Nathan. If you don't want to sort of have to answer it on the spot.
Oh, no, that's fine. I'm more than happy to have a look. I've spent an embarrassing amount of time on this issue because it's just keeps on going. It's like, it is actually like an onion. It just peels back more and more layers and it makes me cry.
While you're looking that up, I'll just say Tina's made a really good point about do we have to go back and contact all our past clients and say, if you are within, have beneficiaries who are within this, category of foreign person, that you may need to revisit it? Oh, so Tina, this is what I think. My annual review checklist says on it, I have a tick box, and it's like, if any of these things happen to you, which includes moving interstate or overseas, and then I've also got, if any of these things happen to your beneficiaries under your will, including moving overseas or back to Australia from overseas, then they need to get an need to come back and have an update. So I think from a compliance perspective, the bare minimum, you could if you send out an annual review checklist with the final documents that has something about, someone going overseas or coming back, I think you're probably covered. Best practice, though, might be to do a newsletter and have like a marketing campaign just saying there's been a change in the law. If, you fall into this kind of category, then come back and see me and we may need to revisit it. So I think, going above and beyond, it would be a good idea to email your clients. If you do send out an annual review mentioning this, though, I think you might be okay. That's my thoughts.
My thoughts on that one, I guess from a negligence point of view and a professional negligence point of view, like it all comes down to whether it's reasonably foreseeable that this was going to be a change in the law when you advised your client. And I don't know, like
I don't think it's reasonably foreseeable at all.
No, like you could probably makes sense. You can see this almost clear line through what a lot of our governments are doing and limiting foreign investment from both the stamp duty point of view in New South Wales, and I'm sure Queensland will probably follow suit pretty quickly. And now we've got these sorts of limitations as well, which I guess were always there. It's just now we're talking about acquiring through a will. So that's the other thing to point out. There have always been these rules. It's just now they also apply to acquisitions through a will. So, is it reasonably foreseeable that they were going to remove that exemption? I don't think so.
Yeah.
So if we go back to that question before, sorry, I just had like a bug in my face. So foreign person is actually just a definition in the dictionary. And that's where I've basically just taken that wholesale. So, and then we have section 5, which actually talks about the meaning of ordinarily resident. So, and I've basically just taken that wholesale as well. So an individual who is not an Australian citizen is ordinarily resident in Australia. So I think from that point of view, we're probably good with Australian citizens. I don't know. And one of the things I should say is, and I have been a little bit slack on it, I'm trying to put together some submissions for the QLS Succession Law Committee to FIRB on this issue that sets out a lot of the uncertainties that we see. And I do need to get moving with that, and that'll be this weekend's job now that this is out of the way and I am all over the legislation. But that's absolutely something I can cover. So thank you for pointing that out, and I'll definitely have a look at that EY law article.
Thanks, Nathan. And look, it is just a one-liner, and they don't really go into it either about that issue. Because I'm thinking, for me, like that's where a lot of the overseas client in like my practice, that's where the overseas client issues come up, where we've just got an adult child who's overseas for God knows how long, but they're not definitely settled over there. They're definitely not coming back. We don't know. I have to say, because of the New South Wales foreign person land surcharge, I have just been excluding foreign people as beneficiaries of the testamentary trust unless there's a specific benefit, the clients we've discussed it and the clients say, no, we probably want to make sure that we can include foreign people because we can see that happening. So I think what I'm going to do moving forward on the planning is include a condition precedent in the will for all gifts saying that, that gift is subject to, or if that gift requires approval or notice under FIRB, then the gift doesn't take effect until that is done, something along those lines. And just have to think about the beneficiaries of testamentary trust and whether they're excluded or not. But this is another thing that has to go on our checklist.
Yeah, and that idea of yours about excluding it until that approval has been given, that's a really good point, because these changes don't take into consideration how assets move through a deceased estate. The fact that the deceased person's interest vests in them as soon as the administration process is finalised, regardless of whether the asset's transferred. So does the acquisition happen at the time of vesting or only when the transfer or transmission documents are signed? Actually,
that's a good question. Someone's asked a question around that as well.
Yeah.
About the timing. Sorry, I'm just trying to find it. Is it assessed, the fact that they're ordinarily resident, is that assessed at the date of death or the date of distribution? Do you know that?
What? I do not. I don't. I would think... I would think at the time of acquisition. That's really the time that it's actually transferred. But I have no grounds to back that up at present.
I mean, surely it's got to be at the time of distribution, like when they acquire the legal interest.
Yeah.
If there's nothing to the contrary in the legislation, I think that would be how it would work then. Because as you say, you can sell the asset and just distribute cash to the foreign person.
Yeah. Like I that's the only way I can see it practically working.
Yeah. So look, I think the purpose of this is to get FIRB on our radar, which Nathan, you absolutely have done. And I think you've done a phenomenal job at sort of covering how far reaching it is and all the various things that we need to think of. And from here, we just have to know that it's relevant on matters, have it on our radar, and I think just dive into the detail when it comes up on your files. And as I feel like this could be a whole day conference and you'd still have questions.
Yeah, you definitely need to spend some time getting used to this legislation, spend some time with it, try and work out your processes. There are some really good guides. I think Ashurst has a fantastic foreign investment kind of walkthrough guide. It's obviously not limited to estates, but it kind of summarizes all of the different types of actions. So I'm not 100% certain that it is Ashurst, but I can try and find it and send that through because it was pretty helpful to me trying to go through that for the first time.
Oh, thank you so much, Nathan. Look, what I might do is wrap it up because we've gone well over time and part of that is my fault from us starting late, but you've been extremely generous with your knowledge and your time today. So on behalf of everybody, I want to thank you. And I also want to thank everyone for your questions and your insights as well. Because, all these questions are really fascinating. So we can continue the discussion in the comments as well. And if you're in the TT Precedents Club, stay tuned because this is on my list to sort out for us and our precedents as well. So thanks again, Nathan, and have a great afternoon, everybody.
Thanks, Tara. See you later.
Bye.